Welcome to Ask the Expert, an award-winning daily series from 8:30 a.m. to 9 a.m. to help small businesses. If you have any questions, please ask them in the comments of the live feed. And if you need any more advice, join the official Intuit QuickBooks SMB community group on Facebook. Accountants and business experts are on hand 24/7. And during the live session, we'll be running a poll, so please do engage with it, and I'll reveal the results at the end. So we're here today to talk about legal risks for SMEs and how to minimize them. I just want to tell you first a bit about LawBite. So I'm the founder of LawBite. LawBite is a law tech company with the mission of democratizing the law for SMEs. We operate as a marketplace between SMEs and expert lawyers. And all the work takes place on a platform which is speedy, easy and affordable for SMEs, generally 50% or less of the cost of working with equivalent lawyers. We operate a regulated law firm on the platform, Law Briefs, and we only use lawyers who have 15 years or more experience, so no shortcuts required dealing with us. And those lawyers cover everything from startup to exit. We've dealt with about 35,000 inquiries from SMEs to date, and you can contact us at the website, lawbite.co.uk, or by live chat, or on the phone, 0207 148 1066. Now you get a free call from an expert lawyer on any matter of your choice when you make an inquiry. So look forward to seeing you on the LawBite website. So we're here to talk about managing your legal risks, and I divide this really into three stages. The first stage is what to do before you start business with somebody. The next stage is what to do while you're in business with somebody. And the third stage is what to do when it all starts going wrong. And I'm sure we all agree that we live in a period of the world's history where legal risks never been more apparent, and managing them takes a great deal of stress away from SMEs. So what to do before you start doing business with somebody? Well, this is something that SMEs often neglect, often in too much of a hurry to get going with new partnerships or deals. So I recommend at this stage that you do some research. Who are you dealing with if you're about to start trading with a new supplier or customer? You can do research via credit agencies. Credit status agencies will give you a report on a particular prospective company or client. You can check on Companies House. If it's a limited company, how are they doing? Have they filed all their accounts? Have they got any charges against them? You can get a feel for their welfare. You can take up bank references, or you can take up trade references, other people who've dealt with that entity. How have they got on with them? Are there any risks or hazards associated with dealing with them? You can also look on something called the Register of Judgments, Orders and Fines, which will tell you if that particular company has any judgments or fines levied against it in relation to previous dealings. That's often a bit of a warning signal about dealing with them. And you can check with the insolvency registers, various insolvency registers, which will tell you if there are any winding up orders outstanding against that company, or if worse still, one of the directors has a bankruptcy order against them, or matters of that kind. So all of this research doesn't take very long, but it can help make sure that you don't just jump into business with the wrong person just because you're in a tearing hurry. So the next stage is what to do when you're doing business with somebody. And here I think that having the right contracts and terms and conditions is critical. So again, SMEs often in a great hurry to get on with things. Often everything's agreed orally or in sketchy email threads. So take the time and trouble to get your contracts, your T's and C's sorted out, and that they cover in particular the responsibilities of each party, the rights of each party, and how to deal with the risks inherent in dealing with each party. You can hedge against those risks in your T's and C's. You can have termination clauses for breach. You can have suspension clauses which enable you to stop all obligations under the agreement, including payment. until a breach has been cured. You can have indemnity clauses in your T's and C's, which entitle you to reimbursement if the other party causes you loss. Sometimes useful if you're exchanging goods to have a clause which enables you to retain title to the goods you're supplying, it retain ownership to the goods you're supplying until they've actually been paid for. This entitles you to go in and recover those goods in the event of non-payment. Good to have interest rate clauses in relation to late payment in your agreement. So you do have a statutory right to interest under something called the Commercial Debts Interest Act, but no harm spelling it out, having a specific interest rate for late payment. And what late payment means, is it 10 days late, 20 days late, 30 days late, 60 days late? Be clear about your credit terms. Generally speaking, the clearer you are, the more clarity in your terms of engagement, your T's and C's, your contract with your customer or supplier, the more you are minimizing the risks of something going wrong. The other thing you can do, in particular in relation to payment risks, is to explore invoice discounting or invoice factoring. So invoice discounting involves a third-party agency paying you in relation to your invoices, so that you get paid ahead of time by the customer, effectively by the agency instead of the customer. Obviously, the agency's not doing that out of the goodness of its heart. It will take a small percentage of the value of the invoice in order for doing that. But still, that de-risks you somewhat in the event of non-payment. Or you can do invoice factoring, which takes that whole process a stage further and enables you to pass the whole business of collecting the invoice, the responsibility for that, onto the third-party agency. Obviously, that then costs a little bit more. So what to do to minimize your risks when it all goes horribly wrong? Well, one thing that's definitely useful to do is to set up in advance a debt recovery program if it's a payment that's gone wrong. So have in advance your procedures all set up, so you know what to do if someone can't or won't pay you. So you can have an escalating series of letters all set out, culminating in something called a statutory demand, which you can issue for debts in excess of £750. And if the person who owes you the money, the debtor, doesn't pay you within 21 days of the statutory demand, then in principle you can start winding up proceedings against them. So it's quite a heavy duty procedure. Most people who get a statutory demand settle the bill pretty quickly. You can also outsource collection of the debt to a collection agency. They're regulated by something called the Credit Services Association, so you can make sure you use a regulated agency, not just some thug who turns up with a baseball bat. But nothing wrong with using a legitimate collection agency to collect money that you are owed. If that doesn't work and it's all gone wrong and you're forced to make a claim, well, obviously there are litigious routes you can go. But my recommendation is generally to use what's called ADR, alternative dispute resolution, things like mediation, where you appoint an agreed third party to help the two of you negotiate a solution, or arbitration, where you appoint a third party expert to adjudge the matter between you. And these processes are generally quicker and cheaper and less stressful than litigation, especially mediation. Mediation normally only takes a day or two and is successful up to 80% of the time in resolving disputes. And that's a lot quicker and therefore a lot cheaper than going through the courts. And you can bake all of these procedures into your T's and C's. So when you set up your arrangements with your supplier or your customer, you can provide in the contract that if something goes wrong, then there'll be a process of negotiation and it moves on to mediation or arbitration, and it sets out the process for doing that and the rules governing the mediation or the arbitration and how you choose the mediator or the arbitrator. And you can set all that out in the contract, so there's no doubt about what happens next if you can't reach agreement on something that's gone terribly wrong. So that's a way of de-risking things when something goes wrong. The other thing I wouldn't underestimate is the value of having insurance in place. Obviously, insurance has got more expensive since COVID, and insurers are generally more risk averse. However, as a generalization, the premium associated with insurance policies is less than the cost of sorting it all out afterwards in the absence of insurance. You'll know that you have to have employer liability if you employ more than one person in a business, that one person being yourself. That's a requirement by law. You've got to have £5 million of employer liability. There are all sorts of other insurance policies you can have: professional indemnity insurance, product liability, director's liability, credit risk insurance against the risk of non-payment by someone you're dealing with, business continuity insurance. These policies are worth having. Obviously, you've got to read the small print, make sure that the excess that you're responsible for, which is the first portion of the loss that you're responsible for in any event, isn't too large. Make sure you can cope with the premium, make sure that everything is properly covered. But as a generalization, insurance policies are a good thing and something to turn to when you're trying to deal with the fallout from risks that look like they're going wrong. So there we are. So there's a number of things you can do before you start doing business with someone, when you're doing business with someone, and when it's all gone wrong, you want to stop doing business with somebody. And hopefully those are all helpful to you. So we're going to look at a few questions now. What are the biggest legal risks to a business if they aren't as data stable as they should be? Well, it's a good question from Yvette on Twitter. Well, of course, we live in an age where GDPR governs data collection and use of data. And so you need to be GDPR compliant in order to avoid the risk of the regulator, the ICO, coming after you and imposing quite big fines if you're not collecting data the right way, if you're not getting consent before you collect data, if you're not getting consent from the particular supplier of the data to use their personal information, if you're not storing it securely, if you're not looking after it while you've got it, if you're not allowing data subjects to have access to their data if that's what they want, or delete their data if that's what they want, if you're not dealing with data breaches in an appropriate and timely fashion. And the ICO can impose fines of up to 10% of your turnover. So it's not a joke. And there have been some very big high profile interventions by the ICO in recent months, normally against larger companies for breaches of data regulations. However, you are not exempt from that as a small company. And if someone makes a complaint about you to the ICO, even if you're a small company, you can be in trouble. So very important to get yourself data compliant. If you want to talk to someone at LawBite about that, it's very easy to do it. You can have a free chat about what it means to be data compliant, how you go about it. You can get an affordable package of documents that will help you be compliant, and ask any questions you might have on that topic. So now we've got Mike on Facebook. We currently outsource a lot of our legal work, but I don't think it's cost effective for us anymore when budgets are tight. How do you measure if it's time to hire in-house? Well, the thing about hiring in-house is there are obviously pros and cons. The pros are you've got somebody on hand who definitely understands your business, is embedded in the business, understands the issues as they come up, and is always there for you. Obviously, having a fixed cost overhead in the business for a lawyer is something that SMEs have to think carefully about, and not all SMEs can afford that. And I suppose the critical point is, how much law do you think you need on a regular basis, and is that worth the cost of having that fixed overhead on your books? Lawyers generally quite an expensive resource, and so that's the balancing act you have to do. Here at LawBite, we try and make sure we're an effective outsourced in-house lawyer for you. We appoint lead lawyers for your business. You can run a subscription policy, which is a lot less expensive than hiring your own in-house lawyer, and that means you've always got a lawyer in your corner who understands your business and can effectively be your go-to person when you've got legal issues that arise, without you incurring that fixed overhead in your business. And if you don't use all of your subscription in a given month, it just sort of rolls over to the next month. So that's a sort of compromise solution. If you can't get that from us, or you can always try getting that from somebody else. Then Side on Instagram, how do we research other businesses we want to do business with? And if we find things like judgments or insolvencies, how do we raise it with them? Well, as I said, there are various registries you can find online that will show you companies that are insolvent or have judgments or fines against them, or are otherwise in trouble. And I think it's legitimate to raise that with your potential business customer. Why not? You can raise it in a diplomatic way. If you're doing research on their credit worthiness, that's sensible. You're not doing it personally. You're doing it to take care of business. And so you can say, look, we have a range of credit checks we do with everybody we do business with. So certainly nothing against you personally. I noticed when we did our standard credit check that this came up about you. I wondered if you could tell me more background about it. So you can be very diplomatic about it, but nonetheless, I think if something like that comes up, it's best to raise it rather than keeping quiet about it. There might be some legitimate explanation. If you don't raise it, you'll never know. Then we've got Kelsey on Facebook Messenger. I think the main reason most SMEs don't have a lot of these conversations up front is because they're worried about scaring off big potential clients or customers by bringing up worst case scenarios. How should we be approaching these discussions? Well, I get that. SMEs are often terrified, understandably, about losing the deal, losing that key customer, losing that key supplier. On the other hand, if you've discovered something a bit unsavory about them, much better to tease that out at the beginning than place your expectations and your hopes and trust in that person and then find they let you down later on. And so I think you can do that when you're raising the information you've found out about research on them. And in terms of your T's and C's, again, I think you can say, look, these are documents we normally work with when we deal with customers and suppliers. We always raise these issues. We're just taking care of business. We're sure you would wish to do the same. If there's anything in there that you are concerned about, please feel free to raise it with me. We're here to listen to your needs as well as take care of our own. But you'll understand why we need to go through the process. So I think if you objectify what it is you're trying to do, no need for people to be insulted or take umbrage at you taking care of business. In fact, it's a good sign that you're a sensible, prudent person for them to be dealing with. What sort of general termination or suspension clauses do you think most supply chain contracts should include? So this is from Tara on Twitter. So the kind of general termination or suspension clauses you might see are a clause that will say if someone is in what's called material breach of the agreement, then you can terminate. And unhelpfully, the law doesn't define what material actually means, but it generally refers to a serious matter, not a sort of minor infringement, a serious matter that goes to the substance of the contract. So good to have a general termination clause like that. Often the clause allows for a cure period, which means that you serve notice if a breach comes to your attention, and the other party has a period of time of 30 days to sort it out before you terminate, and that gives them an incentive to sort of put their house in order, unless what they've done simply can't be remedied, in which case you can terminate straight away. So those kind of termination clauses are quite common, as are clauses that enable you to terminate straight away if the other company gets into financial trouble. If they have a winding up order against them, or they appoint a liquidator or a receiver, or they restructure their debts because they can't pay them on time, or one of a number of similar contingencies, that then will often give you the right to terminate straight away. Suspension clauses are a sort of halfway house. They enable you to suspend performance of the agreement in the context of a breach, to give the other party a chance to sort things out first. So you don't actually terminate straight away, but you suspend it. So you suspend your obligations. So if someone, for example, was in default of payment to you as a supplier, you might suspend the agreement for 30 days so they can sort themselves out, rather than just terminating it. So suspension clauses are quite popular for that reason, because they enable you to go back to the agreement afterwards and just carry on if someone sorted things out. Whereas if you terminate, that's obviously that's it. It's a finite thing, and there's no going back. So those are a couple of examples of general termination or suspension clauses. This is Andrew on Instagram. Historically, I use seasonal staff from the EU, but I'm not sure how it works now. If I do need to hire from the EU, what should I be considering from a legal standpoint? Well, certainly the risks of hiring from the EU have gone up since Brexit. Generally speaking, you need some sort of sponsor license from the Home Office in order to bring EU employees into the country. And I know from personal experience that those licenses are quite difficult to obtain, quite time consuming, and they're quite costly as well. So definitely an area where I would recommend getting some legal advice before you plunge in. Again, business immigration is something that we deal with at LawBite. You can get a free call from one of the lawyers on LawBite who specialises in that area, and they'll sort of take you through the various steps you need to think about. Pauline on Twitter: if it gets to that point, what actually happens in mediation and arbitration? So there's different processes. It depends what you want to achieve. So mediation, you appoint an expert mediator from one of the mediation trade bodies. So CEDR, for example, is a well-known trade body, the Centre for Effective Dispute Resolution. And these are people who are qualified in mediation, they're experts at it. And you appoint an agreed mediator. The idea of the mediator is they're completely neutral. And they are there not to impose a decision, but to help you decide with the other party what the outcome should be. And what they tend to do is get you together on a given day, and they might have you together at the beginning of the day in one room where you can set out your grievance against the other party, and then they will take you off into separate rooms during the course of the mediation, and they will generally engage in some sort of shuttle diplomacy between one side or the other to see if they can tease out a resolution that you might both be happy with. They treat it all very confidentially. They won't say anything to the other party unless you agree that they should. and the whole process is confidential, unlike court proceedings. So it's quite a good way of taking some of the sting out of the dispute, some of the sort of personal hostility. And as I say, it's a success about 80% of the time. Generally, if you can reach agreement, the mediator will help you draft a settlement agreement on the day, and you can go home knowing that that dispute that was taking up so much time is finally behind you. Arbitration is slightly different. Arbitration is actually appointing someone to judge the matter for you, who isn't a court judge. What you do is you generally appoint someone who is an expert in your field, and they then run a process of the decision making. So they follow a process which is a little bit like what you get in court, but with more flexibility around the kinds of documents and evidence the arbitrator will allow. The whole process is set out in the Arbitration Act, so it's the same sort of process every time. And generally speaking, the comfort of deciding things by arbitration is that you've got an expert who can help you arrive at a decision, rather than, some doddery old judge who doesn't know what Facebook or social media is. So that's why people reach for arbitration. So because you're paying for an expert, it's generally speaking more expensive than mediation and does take longer, but still potentially an attractive alternative to going to court. And this is Tommy on Facebook. In order to create staff bubbles, I've changed the shift patterns of the majority of my staff, and now some are getting less hours than they are contracted for. Are there any legal implications from this? Should I amend their contracts? Well, we're getting issues like this all the time from the government's rather confusing and seemingly random pronouncements on how to behave in the workplace as we unlock. So, of course, you've got to balance your duty of care to your staff for their health and welfare with contractual obligations that they may have to you or you may have to them. So generally speaking, my first recommendation is that you talk to people, because if you talk to people, that's much better than imposing a solution, whether you're right to impose it or not. And generally speaking, you can sort out something. Staff will understand that what you're trying to do is keep them safe and well, and that may have some bearing on the way they normally work with you. That said, nothing like having legal advice in the background so that you know where you stand. And so I think it's worth taking a spot of legal advice. Again, you can call us for a free call if you want, as to where you stand in exactly the sort of situation you're talking about. If you can't reach a sort of voluntary agreement with a staff member and they say to you, well, I don't care about being well in the workplace, I don't care about my colleagues being well, I just want you to pay me for 10 hours of work a week because that's what you're supposed to do for me. And so I would recommend having a quick chat with a lawyer about something like that. So I hope that's answered that question and the other questions we've had on the stream this morning. The poll results are in. We asked you, how often do you speak to your lawyer? 0% of you said weekly, 0% of you said monthly, 25% of you said quarterly, and a whopping 75% of you answered, I don't. Well, there you have it. In light of some of the answers to the questions that come up this morning, I hope you feel a bit more confident in future about maybe touching base with a lawyer like one of ours at LawBite, especially for a free initial call, just to make sure you're doing things the right way. So I think that's just about all I have time for today. So a reminder, first of all, I want to thank you for tuning in this morning. If you want to get in touch, please send me an email on clive@lawbite.co.uk. And to find out more about LawBite, visit our website at LawBite, www.lawbite.co.uk. I want to introduce you to your speaker tomorrow, who is Jenna Davis, beg your pardon, a communication and pitch coach at the IAM Hub. So you could tune in to Jenna to learn how to master your pitching and communication skills. And just a reminder that if you need any more advice, you can join the official Intuit QuickBooks SME community group on Facebook. Accountants and business experts are on hand 24/7. So I've really enjoyed answering your questions this morning. I hope the inputs were useful. Have a great day. Thank you.